Well, so very warm welcome to everyone to the first CIPL seminar. My name is Henning Gross Khan. I'm one of the co-directors of the CIPL, which is the Center for Intellectual Property and Information Law. David Ordos, co-director, is here in the room as well. And we got a range of CIPL colleagues and a range of students here. And most importantly, we got Ruth Okediji here as our first speaker. Now, if I was to give proper sort of recognition to Ruth, I would be giving a talk of half an hour. I shouldn't be doing that. So just to say that when I started to work in IP, which is in the late 90s, Ruth has been already around for a while and had been doing amazing, great stuff at the time. So she was always a great role model, which kept me interested, especially in the international dimension of IP. And her talk today will look at a very interesting, developing, and an issue which has been around for a while in international IP, namely the treatment of the cultural expressions, creations, and innovations of indigenous communities and peoples, and how they have or not found a proper place within IP law, especially on the international level. So without further ado, I'll hand over to Ruth. Just to say for the people online, you can just after the talk start, or maybe even during the talk, but we'll only get to that after the talk, start posting questions into the Q&A. I can't promise we'll get to every single one, depending on how many questions we have here in the room, but I'll try to also get some of your questions. So with that, Ruth, the floor is yours. Thank you.
Thank you so much. I understand that I don't need this mic, so I'm not going to pay attention to it. All right, great, wonderful. Let me just say thank you to Porna for not only extending the invitation for me to come, but bugging me until I did. And I really appreciate that. To Henning, to Jennifer, to David, Sina, I'm so grateful to all the co-directors of CIPL. One of the things for those of you who are PhD students, this community of IP scholars is actually quite close, very collaborative, and we go back a very long way, as Henning has said. I'm supposed to speak, Jennifer, for what, about 45 minutes? All right. Okay, perfect. Thank you so much. Somebody tell me when I've talked for too long, because I'm not going to watch the time. So 30 years after the conclusion of the TRIPS agreement, the trade-related aspects of intellectual property rights, a new intellectual property frontier has emerged. So the TRIPS agreement was concluded in 1994. The World Trade Organization celebrated its 30th year in April or May, thereabouts. And right about the same time, we see this new frontier beginning to crystallize, beginning to consolidate, and beginning to take some definition or some form. This new frontier is radically different, it appears at least, from the landscape in which the TRIPS agreement emerged. The TRIPS agreement emerged in an environment in which there were radically different sets of expertise around the global IP negotiating table. It found that developing country and least developed country negotiators were ill-prepared for the complexity of the negotiations happening on IP. And it had very little reflection of the interests and the differences in the innovative capacity of these developing countries. And so here we are, 30 years after TRIPS, with this new frontier emerging. This new frontier has more sophisticated actors from the global south. It has greater status for non-state observers, very different from 30 years ago. Many non-state observers are funded to participate within the process. In theory, actors from the global south have more expertise, they have more visibility, they have more resources. But what does this mean for the normative, the institutional, and the praxis concerns of global IP lawmaking. I want to spend most of my time this afternoon reflecting on my participation in the development of this new frontier and drawing some lessons that I think, at least in my view, are cautionary lessons. So to set the stage for this, I think it's important for us to appreciate the context in which intellectual property lawmaking has been evolving. So if you look at this chart, 1883 marked the zenith of the beginning, the genesis of IP treaty making. And of course, this was the conclusion of the Paris Convention. And if you look, this goes all the way through 2024. And those of you who are familiar with Henning's work or Jerome Reichman's work, you will recognize something quite stark about this data set. WIPO administered treaties, the World Intellectual Property Organization, which is the home of IP lawmaking globally, has been pretty active. But really, the greater activity when it comes to IP norms has been in various multilateral fora. In other words, what we have seen between 1883 and 1993, the conclusion of TRIPS, is a decentralization of IP lawmaking. We now see IP norms emerging in the context of the Food and Agriculture Organization. We see IP norms emerging in the ICC. We see it emerging at the WTO. We see it emerging at the Human Rights Council. So we've seen a massive decentralization of intellectual property lawmaking such that lawmaking in the multilateral context now eclipses lawmaking in WIPO. Now, this is ironic because this is exactly what major emerging economies like India and Brazil wanted back in 1993 as the TRIPS agreement was concluding. So I want you to keep this in mind. A similar chart, but just showing you the clusters in terms of just how intense treaty adoption in the multilateral space has been since 1883 outside of the World Intellectual Property Organization. Now, this gives you a sense of the adoption of these WIPO administered treaties. And again, you see quite a rapid ascension starting from about the post-independence era and a very similar ascension, but greater intensity of activity right after TRIPS, right after 1994. So in other words, we see both a decentralization, but an intensification of IP lawmaking. If you were to describe what was happening in terms of phases, we might refer to the early phase, the 1800s, the late 1800s to the post-war period, as the foundational period. We had the Paris Convention, the Berne Convention, and it was essentially a European vision. It was a Eurocentric model. It was a purely Eurocentric model. A handful of European states became signatories. Those 10 signatories, however, were also the majority global powers. In other words, those 10 signatories controlled roughly 75 to 80% of the governance of the known world. And so in reality, since 1883 and 1886, most of the world has been governed by what we now know as the core obligations of the global intellectual property system. Its normative and institutional anchor was in Europe. It was very much focused on rights and issues about negative externalities, even for Europeans. Issues about Indigenous people did not, of course, play any role in this early phase. The idea was to create a European hub for the governance of innovation that was necessary at the time for the expansion of the European states. Then, of course, the post-war phase, 1945 to 1990. And this was really marked by decolonization. And if you hear nothing else today, I want you to take this core point as one of the key arguments of this project. Every move to decenter European ethos, European models of innovation has led to greater embeddedness of developing and least developing countries into that very system. That's a core argument of this project, that every major decentering has actually produced greater integration of Indigenous people, non-traditional actors, and developing and least developed countries into these ethos. So the post-war phase is where we see this begin. 1945, we begin to see agitation for independence. Former colonies began to accede to these existing IP treaties. WIPO, which at that time was really a bureaucratic secretarial convening place, became the first global IP forum. It very quickly read the handwriting on the wall, became a member of the United Nations, but nothing fundamentally changed. There was a continuation of the existing normative construct, and we began to see, as the world got larger in terms of sovereign states, we began to see not the internal negotiations between European states, but rather a consolidation. Because with the influx of newly independent countries with different economic, cultural, scientific, and political interests, safeguarding the boundaries of the existing foundational work became really important. And so there were agency challenges. Many developing countries retained the laws of their former colonial interests, and those emerging voices that came did not really think about innovation in the developing country context. In other work, I have made the point that the racialized beginnings of the colonial project very much was mapped onto the intellectual property project. Now, let me be clear that, as I've said in other work, that racialized construct, which both sustained and fueled the colonial project, was in fact started in the IP project. For those of you who may recall Edward Gibbon's work and some of the work around the history of science and technology, one of the motivating racializing factors was the idea that Indigenous people, developing countries, colonized people, simply lacked the ability to engage in science and technology. And part of the rationale for colonization was precisely that perceived gap. And often the history is told very differently. The history is told as a colonization as a principally a political project that then bled into IP. And I have maintained that it was in fact a technology project that then became a political project. And we can talk about that in other work, but the post-war phase became very much about assimilating these sovereign states who lacked agency into the existing framework. There were some acknowledgements. India and Brazil particularly negotiated and insisted that there be an acknowledgement of the different levels of development, and the Berne Appendix is your best example. Then we move to the third phase, the globalization phase. And here we see, of course, the emergence of the TRIPS agreement. There is a drive towards harmonization, fueled, once again, notice the thread, fueled not by the political state, not by the Westphalian state, to quote Tony Angie, but actually fueled by major corporations. And one of the things I'm doing with this project is drawing the historical line between what we see now and what was referred to as big tech and the shaping of global norms, and what we knew back then as multinational corporations and the shaping of IP norms. Developing countries began to engage in transactions over IP standards that really were inconsistent with their development needs. And ultimately, the TRIPS agreement emerges not as a normative or even deeply contested negotiation about innovation and science and technology, but rather as a place in which we found the privatization of global forces emerging. So the TRIPS agreement and the standards for intellectual property protection that emerge are not a reflection necessarily of policy interests or normative priorities of even the developed countries, but rather fueled by the interests and the needs of consolidated economic global firms who were operating across national borders. Negative externalities, public interests were formally acknowledged, such as in the introduction and in the acknowledgement and with limitations and exceptions to intellectual property, but they lacked teeth. So here's what you see as the data proving the point that every decentering actually ended up embedding these countries more and more into the system. So here is data about the Paris Convention ratifications from 1883 to present. The orange dots are developed countries, and the black dots are developing countries. Now, if you look at the history of technology, this should not be surprising. That typically technologies, natural resources, any extractive global system requires the participation of the weaker, the marginalized, the less capable politically, in order to advance the core claims of their regime. So here you see the number of developing countries, 136 developing countries to 40 developed countries. If you look at the ratification line, these are the developed countries, and you will note the developed countries high up in 1880. They begin to cluster in the early 1900s. They dip off all through the industrialization era. Notice very little activity by developed countries. And then right around the negotiation of the TRIPS around 1989, we begin to see developed countries again pull in. The same thing, but if you look at developing countries, very little ratifications until you get close to independence. You see the independence era, ratification, and then of course, a fairly significant ascending of these ratifications, 136 member countries. If you look at the Berne Convention, a very similar story, 44 to 135 developed to developing country numbers. And here again, the rate of accession, radically different than what you see in the developing countries. So compare this with major countries staggering, sometimes completely stalling as economies adjusted, and compare that to an almost unbroken chain of accession in the global South. Okay, so what does this mean for Indigenous people? And what does this tell us about the recently concluded treaty requiring the disclosure of any use of Indigenous peoples' knowledge, genetic knowledge, in a utility patent system? This is a treaty that was concluded in May of this year. The negotiations for this treaty began in 2000, so we're talking over a 24-year period. And there was a lot of clamoring for this treaty by the Global South, by Indigenous populations, and a lot of resistance by firms in the Global North. Between 2000 and 2024, some very important things were happening. I want to show you this in this chart. So if you look here, In 2005, this is, of course, almost 10 years after the TRIPS agreement, you had about 62 cultural preservation programs. You had about 27 cultural property laws. Now, this is crucial because in the earlier charts that I showed you, what was happening is that cultural knowledge, genetic knowledge, was viewed as the common heritage of humanity and therefore was fuel for the intellectual property system. And so all of the accessions and all of the ratifications of formal intellectual property treaties were done in a context in which the assumption was that there was no innovation, no knowledge, no value economically to be had from Indigenous communities. So most of what we saw in 2005 from the multilateral system, from regional systems, were cultural preservation programs, museums, antiquities, etc., and cultural property laws, mostly soft laws. Look what happens by 2020. We have 134 laws for cultural property. And look at cultural preservation programs have increased by a factor almost of 4. So what's happening? We see an ascension of ratification by developing countries. We see this mushrooming of these cultural property laws. What is happening? Let me show you what these laws are, because I think it's easy in an era where we're talking a lot about reparations, we're talking about return of cultural property, we're talking about Indigenous identity. What are these laws about? So just to be clear, yes, there are lots of cultural preservation laws. There are lots of laws about burial sites and repatriation, sacred and ceremonial sites. And again, you can see the massive jump in these laws. And whereas we had 0 IP laws that were being developed by Indigenous communities and multilateral institutions, today we have 48. What has happened? The process of contestation within the global setting transformed Indigenous people, non-state actors, even many developing countries, into from external sort of observers of the system and gave them a stake in the system the minute these laws began to emerge. Because someone has to defend these laws in global fora. Someone has to represent what they represent. So data sovereignty, you went from 0 to 49 very quickly. Intellectual property and other forms of intangible property, you went from 0 to 48. We now have Indigenous communities managing, prescribing, announcing, modifying statutes that govern intellectual property and data and other intangible property within their own legal regimes. That very act of sovereignty has had profound implications for the intellectual property system and for the debate and the theorizing about the extent to which the intellectual property system ought to be accountable to other global regimes like human rights, like environmental law, and so on and so forth. So this is happening with Indigenous communities and their exercise of sovereignty. If you look at the 10 poorest countries in the world, we see the exact same thing. Of course, acting as sovereign states, they're not passing new laws. They're simply ratifying existing intellectual property laws. But something is different about what is happening in the poorest, weakest, institutionally fragile members of the global community. And what is happening? The intellectual property treaties that are in theory more favorable to economic growth and to the exercise of agency are the least ratified by the poorest members of the global community. And the intellectual property treaties that are the least agile for economic development and public welfare interests are the most ratified. And you see this in a comparison of the Marrakesh Treaty, which is a treaty that was long fought for, with which I was involved in the negotiations, to ensure that visually impaired people have access to copyrighted works, versus the foundational treaties of the Paris Convention and of the Berne Convention. All right, so this should tell you something, as I said, about the political economy, but also the normative content and the normative power of the foundational treaties of the global IP system. So let's just take one of these countries, some of the poorest in the world, and I want to show you the stark challenge that we see here. So Cameroon is one of the poorest countries in the world. And if you look at Cameroon, this is the penal code. Not only are we seeing rapid ratification of less welfare-oriented IP treaties, we are seeing greater penalties for IP violations, greater than what we would observe in the UK, in the US, and in other industrialized countries. So here's Cameroon with a GDP that most cannot even begin to imagine. And here is the penal code of Cameroon imposing a 5 to 10 year punishment for copyright infringement. The criminalization of intellectual property violations have gone hand in hand with the exercise of political sovereignty and with the intensification of ratification of IP treaties. Now, what is startling is if you look at this, Cameroon's 2023 GDP was $1,722. The fine for copyright infringement, $831. Other crimes that are punishable by a 5 to 10 year prison term, like copyright infringement, public employee corruption, striking money, so the forgery, armed riots, torture, assault, rape, infanticide. These are the crimes that are at par with copyright infringement in some of the poorest countries of the world. So what does that indicate for the massive amount of scholarship that has gone into the fight over the global IP system? First, the fundamental assumptions have not changed in over 200 years. I was speaking to a doctor recently who was describing sort of multi-drug resistant bacteria. And essentially, intellectual property is a multi-drug resistant regime. For over decades since the TRIPS agreement, there has been efforts, lots of scholarship, contending, contesting, and questioning. But the racialized views of what it means to progress has made it increasingly difficult to not only insulate a racialized theory of IP, but also to create an IP system that is in fact yet more balanced. This is so despite the overwhelming lack of evidence that intellectual property in fact has a welfare increasing impact on developing countries. What we have instead seen is a creation of export monopolies. We've seen a wealth transfer, and we've seen, of course, the consequences of a global public health crisis. What else are we seeing? Continuing on with the racialized foundations, we also see that Africa in particular, and Oceania, so the Asia Pacific and the African countries are the least, have the least number of users of the system. In other words, the same numbers that pertained in 1883 and 1886 have largely stayed the same throughout the course of history. So what does that mean when you see these sorts of numbers? Well, a couple of takeaways that have implications for this recent treaty. First, as I said, this new frontier features many new actors, importantly, non-governmental organizations who now have legal status and can participate in the discussions and in the negotiations at WIPO. But one key takeaway is that the involvement of non-governmental organizations has been neutral at best. There's an extraordinary amount of capital and an extraordinary amount of influence that these non-governmental organizations wield at the national level. But in terms of setting the agenda and setting the norms, these NGOs have had minimal impact in terms of transforming the central themes of the global IP system. This was evident in the WIPO copyright treaty, which in theory was won by developing countries, but in reality, developing countries became key stakeholders in this treaty. NGOs participating then, 76, back in the Berne Convention, only 26 were present. And yet again, so just in case you missed it, so this is the WIPO copyright treaty. Lots of NGOs participating, supporting developing countries and indigenous people groups. But look at where the ratifications are. Almost entirely in the industrialized, globalized. Going back to the theme of the project, that the more decentered you see these treaties, the more entrenched and the more dependent on the agency of developing countries and indigenous people we see. What has happened? We have transformed in the process of engagement and in the process of inclusion and in the process of sovereignty, we have transformed those who bear the brunt of the public welfare concerns of the IP system. We have transformed them into the ones who fuel and in many ways make the system possible. Second takeaway. Developing countries are most effective in global IP lawmaking when they are most aligned with US-EU constitutional impairment claims. And so this is, of course, epitomized by the Marrakesh Treaty. The Marrakesh Treaty sought to increase the global availability of books, but if you look at the number of illiterate populations in the global South, they have not fundamentally been helped by the conclusion of the treaty. And so what does that mean? Very similarly, look at the ratifications of the Marrakesh Treaty. And you can see Africa, lots of parts of Oceania, again, non-ratified. Third point, colonialism's long tail continues to shape developing country alliances in global IP lawmaking. The Lisbon Agreement. This is a bitterly contested international treaty. Developing countries had very little politically at stake, but because the European Union deeply was vested in the Lisbon Agreement, virtually every Francophone former colony participated in here. So if you look at the Lisbon Agreement, it is heavily divided by the colonial histories of the developing South. And so again, you find that that long tail of colonialism continues to show up in the global setting. And so here is the map. This is the Lisbon Agreement. In blue, you can see most of French West Africa that has been covered by very quick ratification and accession of the Lisbon Agreement. All of the Anglophone countries are completely out of the Lisbon system. And finally, what is perhaps the most troubling takeaway for me is that maximalism prevails. 30 years after the TRIPS agreement, 30 years of fairly intense and significant scholarship, we have yet to see a meaningful reshaping of the contours of the patent system, copyright system, the trademark system, or the design system. And that is, of course, most evidence in the Intergovernmental Committee that oversaw the development of WIPO's most recent genetic resources treaty. As I said, this was a negotiation that began in 2000. And in May of this year, the diplomatic conference concluded there are two treaties that are going on still, traditional knowledge and traditional cultural expressions. So what does this treaty do? The treaty is a mandatory disclosure of origin treaty. Developing countries wanted it to extend to every form of intellectual property in the negotiations, and finally, in its conclusion, it applies only to utility patent applications. In December, there will be the negotiations, the diplomatic conference for the Design Law Treaty, and we will see where that goes. But for now, the Genetic Resources Treaty is concluded. Why did developing countries want an intellectual property treaty? Colombia in 1999 pushed for this, and over the last 24 years, every developing countries has joined in support. Well, there are a number of reasons. One is that disclosure of origin requirements can facilitate access and benefit sharing under the environmental law treaties. So the synergy and the decentralization of intellectual property that I mentioned earlier at the beginning of the talk has found its way back as a justification for a new form of intellectual property treaty. So for developing countries, a disclosure of origin, whenever you access the indigenous knowledge, indigenous genetic knowledge of indigenous people, that disclosure requirement facilitates the tracking of ABS obligations. In much of the discussions, these countries argued that disclosure regimes can be used to identify violations of domestic prior informed consent laws, access and benefit sharing laws, and material agreement transactional laws. So pick ABS and MAT. Where is all this coming from? This is, of course, coming from the international environmental law regime, where developing countries and indigenous communities have been extremely active in wanting to preserve, in the name of preserving biodiversity, the interests and the knowledge of indigenous people. Indigenous people and developing countries also felt that the existence of a DOO requirement would be a deterrent to non-compliance with national protection regimes. For example, where, as you saw, many of the laws being passed by indigenous people, Native Americans in the United States, required that you obtain permission before you use the knowledge. And then, of course, increasing number of countries include DOO requirements for some type of IP rights. So in China, for example, you already have to disclose the origin of the genetic resource. So, you know, the Genetic Resources Treaty really was a way of integrating intellectual property, human rights, UN DRIP, and of course, international environmental law. The Africa group that I represented in the negotiations was very interested in the treaty for the similar reasons. The argument was that it facilitates policy coherence, it strengthens complementarity, it provides domestic policy space for legal experimentation. There was a whole package of rationalizations for why this treaty was necessary. For 24 years, indigenous people and the Africa group and developing countries made the case for this new treaty. And of course, they got the treaty. But what did they get? They got a treaty that strengthens the patent system. The objectives of the treaty, there are only two provisions of this treaty that you need to know anything about: the objectives and the obligation. The objectives of the treaty are to enhance the efficacy, transparency, and quality of the patent system. Those are the goals. To prevent patents from being granted erroneously. Now, this is key, because for those of you who are students of international law, you understand that every time there is an imperialist move, every time there is an expansion of the shadows of colonialism, it is always to defend an archetypical norm necessary for the functioning of a global economy built largely around anti-competitive industries. That story, which started in 1883, has not changed. It has not changed. And so when I describe the IP system as sort of similar to a multi-drug resistant bacteria, this is what I mean. So after clamoring for the treaty for years, the treaty does what? It defaults to defending the extant regime, which in theory was what indigenous people in developing countries were fighting against. It's hard to read this slide because of so many words on it, but this is Article 3, the disclosure requirement. And I just want to point out a number of things that codify the racialized globalization of intellectual property that has defined the norms of IP in a way that rationalize its unbalanced effect, not only between and among countries and indigenous groups, but even within developed countries themselves. So this is the core provision of the new WIPO treaty, where the claimed invention in a patent application is based on genetic resources. Each contracting party shall require applicants to disclose the country of origin of the genetic resource. In cases where the information is not known or where it does not apply, they must disclose the source of the genetic resources. Where the claimed invention is based on traditional knowledge, they shall require applicants to disclose the indigenous people or local community as applicable who provided the knowledge, or where they do not know, they must disclose the source of the traditional knowledge. If you read Article 3.1 in the context of the history of science and technology, what it does is ratify the lack of scientific inquiry with regard to the communities in which biological resources are in fact extracted. The disclosure obligation requires you to give information about where you obtained it from, but does not impose an ethical obligation for you to determine that it was obtained properly, obtained with permission, or obtained even from the group that knew it. The second part of the disclosure requirement says if you do not know any of this information, then you make a declaration to that effect, and then the contracting parties shall provide guidance as to how to make the obligation. And if you look critically at 3.5, there shall be no obligation on offices to verify the authenticity of the disclosure. Many of the victories that are so counted by the intellectual property system are victories that are viewed as victories because developing countries or indigenous communities were at the forefront of the demands that were being made. They were viewed as victories not because substantively they reflected a different rationalization of the participation of indigenous people or local communities in the IP system. Rather, indigenous communities, developing countries, have become in many ways the new agents of a regime that systematically denies the balance that is necessary for these communities globally to benefit from the global innovation system. And so my prediction is that we will see many more treaties that look just like this. Article 1 and Article 3 of the new WIPO treaty are not actually the most egregious parts. The most egregious parts are provisions that administer the treaty that allow non-members of the treaty to participate in the governance of the regime. And so once again, we've created in many ways a system in which the innovation benefits are unevenly skewed, but that skewing is obscured by the possibility that we can rationalize the end results because of the leadership of Indigenous people themselves. And so, to answer the question with which my talk began, will Indigenous peoples' knowledge change the intellectual property system? The answer, in my view, is not anytime soon. Thank you so much.